Hello and welcome back. I'm attorney Andrew Bethel, Bethel Law, here to help you grow your estate and create generational wealth. Today, let's discuss whether it's better to use an LLC or an S-Corp to hold your rental property. The answer is an LLC. Oh, you want to know why? All right, I'll teach you. Hit the like button, subscribe, and share the video with your real estate person. Class is in session. Before we get into the nitty-gritty, let's briefly discuss what LLCs and S-Corps are. An LLC, or limited liability company, is a business structure that combines the liability protection of a corporation with the tax benefits and flexibility of a partnership. On the other hand, an S-Corp, or S-Corporation, is a special type of corporation that's designed to avoid the double taxation drawback of regular C corporations. Instead of being taxed at the corporate level, income is passed through to the shareholders and taxed at their individual rates. One thing to note is that depending upon the type of business, you may be restricted from operating as an LLC and may have to do an S-Corp, partnership, or sole proprietorship. I have a whole video where I've discussed that before. However, when it comes to real estate investing, you aren't restricted from using either an LLC or an S-Corp. However, depending on which structure you might choose, you may be subject to a California statewide rent control regulation, which I'll get into in just a bit. Now let's talk about why an LLC might be better fit for holding your rental property. The first major advantage is simplicity and flexibility. Fewer formalities. LLCs are easier to manage, unlike S-Corps, which require regular board meetings, keeping detailed minutes, and adhering to strict bylaws. LLCs don't have these stringent requirements. This means less paperwork and fewer administrative headaches. Imagine running a rental property without having to worry about organizing board meetings or keeping meticulous records of every single decision you make. Sure, I suppose you could just not do those things, but failing to follow corporate formalities is one of the methods by which a clever lawyer will try to pierce the corporate veil and hold you personally liable in a lawsuit, which is the main purpose of creating the corporate structure in the first place. Liability insulation and protecting your personal assets from vexatious litigators. Flexible management. With an LLC, you have the flexibility to manage the company yourself or appoint managers. There's no need for a board of directors and officers as required in an S-Corp. This flexibility can be particularly beneficial if you're a small real estate investor who prefers a hands-on approach. Next, let's dive into the tax benefits, which is where the LLC really shines compared to an S-Corp, especially when it comes to rental properties. Let's first talk pass-through taxation. Both LLCs and S-Corps offer pass-through taxation, which means that the business income is reported on your personal tax return. However, LLCs typically allow for a more straightforward pass-through of rental income and losses. This can simplify your tax filings and avoid some of the complications that can arise with S-Corps. Next is the big one, step up in basis. Here's a critical point that makes LLCs highly advantageous, step up in basis. When you pass away, your heirs can inherit the property with its value stepped up to the current value at the time of your death. This significantly reduces capital gains taxes if they sell the property. For example, let's say you bought a rental property for $200,000 and it's worth $500,000. When you pass away, your heirs would only pay capital gains tax on any amount above $500,000 if they sell it. This step up in basis does not apply to assets owned by an S-Corp. Going back to our example, that's great that the property is worth $500,000 at your death. Your beneficiaries would pay capital gains on your tax basis, the original purchase price of $200,000 versus the sales price. So instead of paying zero in capital gains taxes because they inherited the property directly or through the LLC, they're going to pay up to 20% in tax on that $300,000 appreciation. Or to put it plainly, they either pay $0 or $60,000. I think when we look at capital gains in a stepped up tax basis, the answer is almost a no-brainer. The LLC is just plain superior. But wait, there's more. As I mentioned before, both LLCs and S-Corps provide limited liability protection, shielding your personal assets from business liabilities. However, LLCs achieve this with fewer complications. With an LLC, you don't have to worry as much about losing your liability protection due to administrative oversights. S-Corps require strict adherence to corporate formalities, and failing to follow those can sometimes jeopardize your limited liability status. Remember what I said before? Piercing the corporate veil and subjecting your personal assets like the family home to creditors and that person who slipped and fell in the pool, all because you didn't hold your required board meetings with minutes, would probably make you feel a tad grumpy. With an LLC, as long as you keep your business and personal finances separate and follow basic operational rules, you maintain your protection. Now let's consider the treatment of real estate transactions, which is another area where LLCs have the upper hand. No double taxation on distributions. With an LLC, you can distribute profits or even the property itself to the members without triggering extra taxes. In contrast, distributing assets from an S-Corp can sometimes lead to a double taxation, first at the corporate level and then at the individual level. This makes it easier and more tax efficient to transfer ownership or distribute properties with an LLC. Next, we go to cost. Cost is always a concern for any business, and it's no different when deciding between an LLC and an S-Corp. In California, both LLCs and S-Corps must pay an annual franchise tax of $800. However, LLCs also face an additional gross receipts based on the revenue. While this fee might sound like a disadvantage, it often remains more cost-effective than the potential double taxation issues with an S-Corp, especially for smaller rental operations. Again, if you have one or a handful of rental properties, then there's no need to get too complicated. Keep it simple, keep it inexpensive. When it comes to estate planning and transferring ownership, LLCs again prove to be more advantageous. Transferring ownership interests in an LLC is typically simpler and more flexible compared to an S-Corp. There are no restrictions on who can own an LLC, whereas an S-Corp has strict rules about who can be a shareholder. No non-resident aliens, no corporations, and a cap on the number of total shareholders. However, this is where we come back to that California statewide rent control issue I mentioned earlier. I did a video a while back about the California Tenant Protection Act of 2019, also known as AB 1482. Now, watch that video for a deep dive into the details, but don't worry, it's shorter than this video. But to summarize the relevant facts here, California has a statewide rent control regulation setting a minimum floor. That means your city or county may have other regulations to be aware of. However, what AB 1482 does is it restricts landlords from raising rent more than 5% plus the local inflation rate, or 10%, whichever is lower, in a 12-month period. Not everyone is beholden to this blanket rent control. If you own the property personally, then you don't have to play by these rules, at least until they decide to lump you into this too. But the question then becomes, if you own the property in an LLC or an S-Corp, are you subject to that regulation? Well, you're going to see a lot of wrong information out there where people say if it's in a corporate structure, then you're subject to the regulation. No distinction between LLC or a corporation. However, I'm here today to tell you that people are being lazy. Maybe. But if you have a rental property in an S-Corp, then yes, you are subject to AB 1482, meaning you have to abide by the statewide rent control levels. Alternatively though, if you have that rental property in an LLC and none of the members, meaning the owners of that LLC, are corporations, then you're not subject to 1482, meaning you are not beholden to the statewide rent control regulation. You can have an LLC or a corporation own an LLC, but if you do that, then that rental property owned by the LLC is subject to AB 1482, even if it's a 1% ownership interest. Why would you have an LLC owned by another corporate entity? Well, that's a whole other can of worms, which we do not have time for today. So I'll link to a recent video where I tell you about how to hide who owns that rental property. For now, if that rental property isn't an S-Corp, then AB 1482 applies, meaning statewide rent control. If that rental property is in an LLC and the owners are individuals or a trust, then AB 1482 does not apply and no statewide rent control regulation. Lastly, let's talk about some potential tax traps you might encounter with an S-Corp that you can avoid with an LLC. No built-in gains tax. When converting a C-Corp to an S-Corp, there's a risk of built-in gains tax if the property is sold within 5 years. This concern doesn't exist with an LLC, making the tax situation more predictable and less risky. Imagine planning to sell a property, suddenly being hit with an unexpected tax. That's a scenario you can avoid by choosing an LLC. Or maybe not investing in California real estate in the first place. Watch my video on the mansion tax for more on that. In summary, choosing an LLC for holding rental property in California offers simplicity, flexibility, and significant tax advantages. It protects your personal assets with fewer formalities, provides clear tax benefits, and makes estate planning and transferring ownership easier and more cost-effective. An LLC minimizes the risk of unexpected taxes and administrative burdens, making it the preferred choice for many rental property owners. But what do you think? Am I blowing all this out of proportion? I'm not, by the way. Do you or a loved one have a rental property and now you know to pull the trigger on setting up that LLC? Let me know in the comments below. Thank you again for watching. Like, subscribe, share the video with someone who owns rental property or is thinking about it. We all know that person. I'm attorney Andrew Bethel, and I'll see you at our next meeting.